Good afternoon, ladies and gentlemen. It's nice to join you or meet with you, even if it's virtually. This afternoon, we're going to talk for a little while about collections, how to get your money. A little bit of background, our firm and myself, so Cleveland Doan, the firm that I'm a partner at, we've been doing strata property work since July of 2000. This is now my 22nd year of the practice of law. We deal with a number of issues, well, actually all issues related to stratas, but we have a particular focus on collections, bylaws, drafting and enforcement, CRT claims, and my favorite governance matters, meetings and the conduct of meetings. So as I was putting my mind to this presentation, this famous quote from the Jerry Maguire movie came to mind, "Show me the money." And that's essentially what we're talking about today, is how the strata corporation's going to get the money that's owed to it. And so I thought I'd start with asking the question or surveying the topic, why is collections important? What is important about collecting money? So the one thing we have to remember is when it comes to strata fees, that's the strata corporation's only source of funding for common expenses. It doesn't get revenue or very much revenue from anything else. So that's why it's important that owners pay their strata fees and the strata collects them. The strata it's not a bank. So it's not in the business of carrying expenses for owners. So where it's expended money to do something, repair something, pay a deductible, it should be recovering that. And the fact that fines generally aren't effective unless they're paid. Quite often, just simply putting a fine on a ledger isn't going to have much of a deterrent to certain owners. There are also a number of practical considerations that go beyond this. If the strata corporation has monies that are outstanding, then it could mean that bills are going unpaid. It ties up the strata corporation surplus to fund those shortfalls. It also inflates the balance sheet. You could have a number of ARs on the balance sheet that are showing there but aren't being collected. And more importantly, it sends a message. How you deal with arrears sends a message to owners about how serious you are. How serious are you about making sure that they pay their strata fees, that they pay those deductibles for which they're responsible, or more importantly, that they pay the fines. If all those simply go by the wayside, then certain owners are going to pick up on that and simply say, okay, well, I don't have to pay because the strata doesn't make me pay. So there are three basic categories of money that are owed to strata corporations, and we're going to look at each of the three of these today, and then talk about how to collect them, which goes beyond just the mechanics of going to the CRT. There's, in many cases, a lot of groundwork that needs to be laid first in order to be successful. The three categories are chargebacks, and I'll talk about in a moment, define what I mean by that, fines, and then strata fees and special levies. The term chargeback is not a defined term, but it's a term that's used quite often in the strata world. It's essentially anything that's not a strata fee, special levy, or a fine. And it includes things such as insurance deductibles, the cost to repair damage to the common property or to a strata lot, inspection or investigation costs, and bylaw enforcement costs, including legal fees. Phone hasn't rung all weekend and it has to ring now. All right, so back to what are chargebacks. So those are generally the things that we talk about when we're talking about chargebacks. There's a general rule that gets applied to chargebacks. And that rule is that in the absence of a bylaw or a rule giving authority to do so, the strata corporation cannot charge an owner for costs it has incurred. And that comes from the Court of Appeals decision in Ward. So in other words, if you're going to charge something back to an owner, there has to be a bylaw to do that. There's a couple of exceptions to that. One of those is a bylaw is not required where an owner agrees to pay the costs. which often arises when it comes to repair of damage to a strata lot. An owner may agree to have the strata coordinated and pay for it, in which case you don't need a bylaw. The other is Section 133 of the Strata Property Act that allows the strata to charge back the cost of remedying a bylaw contravention. And I'm going to talk about that in a few moments in some more detail. But for now, I'm going to focus on just the general chargebacks. So the Ward decision or Ward principle has been applied by the Civil Resolution Tribunal in a variety of situations. So anytime that the strata is trying to collect money from an owner, the question that it has to ask is, what's the basis for requiring the owner to pay that amount of money? And so the CRT has applied this Ward principle in a number of quite common situations. So one of them was the plumbing repair costs in the Robertson decision. So the strata had undertaken some repairs to, I believe it was the owner's toilet as a result of a leak. It had, of course, incurred a plumber's bill and tried to charge that back to the owner. And the CRT wouldn't allow the strata to do it because it didn't have a bylaw that allowed it to do that. Similarly, there's a clearing of a blocked pipe. So the strata had to go clear a blocked pipe, tried to charge that amount back to the owner. The CRT looked at the bylaws and said, do you have a bylaw that allows you to charge that back? It's also applied it in investigating costs incurred to investigate to find the source of a leak. It's a very common scenario. Strata Corporation gets a call, there's water in someone's unit, no one knows where it's from. The strata sets out to investigate the source of that leak, calls in a plumber, they dig around, incur some costs, and then determine, oh, well, it wasn't a common property pipe. In fact, it was the owner's sink or toilet or tub or whatever it may be, and then tries to charge that amount back to the owner. If the strata is going to do that, the CRT has said you have to have a bylaw to charge those costs back. Similarly, emergency drying costs. So if there's water damage to a strata, the CRT has said you have to have a bylaw that allows you to charge that back. You can't just charge it back to the owner because it is their strata lot. Along the same lines, repairing damage to a strata lot. In this particular case, the strata, or there was damage that came from the common property. I think it was a roof leak, caused damage to the strata lot. The strata went ahead and repaired it, then tried to charge it back to the owner, saying, well, it was your strata lot that was damaged, and you benefited from the repairs. And the CRT said, no, you can't do that because there's no bylaw that allows you to do that. Along similar lines, the CRT has said if the strata undertakes mold abatement work in a strata lot, it can't charge that back to the owner unless there's a bylaw. The reference engineering fees, in that particular case, the strata had incurred engineering fees in relation to an unauthorized alteration. It tried just simply to charge those back, not relying on Section 133 of the Act, but just charge them back. And again, the CRT said, well, you don't have a bylaw, you can't charge that back. Some other common scenarios where the CRT has applied this Ward principle, replacing a damaged smoke detector and charging that back, you need to have a bylaw. Bed bug treatments, so in this particular case, the strata had to treat some surrounding units for the presence of bed bugs, tried to charge it back to the owner, wasn't allowed to because it didn't have a bylaw. Locksmith fees for gaining entry, and then even legal fees. So if the strata incurs legal fees to deal with a situation, it can't simply just turn around and charge those back to the owner because they feel the owner is responsible. It has to have a bylaw or another legal basis to be able to do that. Now, those bylaws could be specific bylaws dealing with specific situations. So for example, legal fees, you might have a bylaw that just addresses legal fees. You could also have an omnibus bylaw that addresses a number of different situations, investigating sources of noise, sources of water, making sure things are up to code, replacing smoke detectors. You could put that all in a single bylaw. no matter what way you do it, you have to have something to fall back on in order to be successful when you move to the next step of trying to collect these monies. One of the very common scenarios that arises, and you look at in the CRT cases, is recovering insurance deductible and damage repair costs. So this is where usually 99% of the time it's a water leak. So these are situations where water has leaked from a toilet, a supply tube from some source within a strata lot has caused damage to other units below. Strata corporations are going to try and charge that back. So if it's the full deductible, they're going to try and charge that back. If it's less than the amount of the deductible, there may be just some out of pocket expenses, which refer to damage repair expenses. They are going to want to try and charge those back. If you read the cases, success in those situations is dependent on two things. One of which is a good bylaw that sets the correct test and addresses situations where there isn't a deductible. And the other is good evidence. So in a lot of the cases, the question is going to be proving where the source of the damage arose, where the water came from. So while you're in the midst of sorting this out, it's good to make sure that the council members involved are taking notes and photos, that your restoration companies are taking notes and photos, the plumbers, etc. Gather all that evidence early on. Because I have had cases where we've gone back a year and a half later to try and find the plumber. Well, he no longer works for that company, and they're very hard to track down. So get your evidence to start with. And having the right bylaw is going to become more important as deductibles continue to increase. If you've incurred a deductible, the strata can always fall back on section 158(2) of the Strata Property Act that allows it to sue an owner who is responsible for the damage, giving rise to the deductible. If we're talking about repair costs that fall below the deductible, so there's been no insurance claim made, that principle becomes a lot more difficult to apply. And that's where a bylaw becomes important that allows the strata to charge back the repair costs and the emergency response costs that it's incurred. If you don't have that bylaw, you're likely not going to be able to recover those monies. When we're talking about bylaws that address insurance and repair, damage repair chargebacks, it's important to have the right language in it. So you'll see section 158(2) refers to the term or the word responsible. And that's been interpreted by the court as equaling a strict liability principle. The question being, did it originate in the strata lot? So if the source of the water originated within an owner's strata lot, they are responsible for the damage. Strata Corporation doesn't need to prove that they were negligent or that they failed to do something or did something. They simply have to prove that the source of the water was within the unit. Now, where this or where the rubber meets the road on this is if you haven't updated your bylaws. There's a number of older bylaws that refer to the term negligence. So they say that an owner will be responsible to pay the deductible or the damage repair costs where they or someone for who they're responsible have been negligent. And there's similar other terms used. Some bylaws don't specifically use negligence, to talk about omission, error, etc. But where you use a term other than responsible, the court has held that what you've done is set a standard that's not a strict liability standard. So you now, in order to charge that deductible back, you have to be able to prove that the owner was in fact negligent. And it starts to become a bit of a parsing of the terms of the bylaw if it uses other words other than negligence. Now, sometimes that's not difficult to do. There is a general presumption that if water comes from above, it's due to negligence. And the courts sometimes, and the CRT as well, will do what I like to call legal gymnastics to get you there. So in the Morrison decision, the court found Mr. Morrison was liable for a toilet overflow due to his negligence of not having stayed in the bathroom long enough to wash his hands in order to realize that the toilet had clogged and overflowed. But I strongly urge all the stratas I deal with, and I'd urge your stratas to check your bylaws, make sure you've got the proper language, not referring to negligence. And it'll certainly make being able to collect those amounts much easier. Now, I had talked about an exception to the general rule of you have to have a bylaw. And that exception is Section 133 of the Strata Property Act. That particular section allows the Strata Corporation to do what is reasonably necessary to remedy the contravention of the bylaws and to charge the reasonable costs of remedying that contravention back to the owner. So sometimes this is relied on where there's damage that has been caused. And there's this trio of cases I'm going to talk about later in the presentation, but they're VR2, 266 and 228 Chateau Boulevard. And in that particular case, there had been a hot water tank that burst and caused damage to the common property below the unit. They didn't have a particularly good chargeback bylaw, so they didn't rely on it. And also, there was no deductible because the damage was well below the $50,000 deductible. So in that particular case, the Strata relied on standard bylaw 3 sub 2, don't cause damage to the common property, and charge the cost back to the owner, or attempted to charge the cost back to the owner under Section 133. The key, though, to relying on Section 133 is that you must comply with Section 135. If you don't comply with that provision, then you're not going to be successful in recovery based on Section 133. I will talk when we get to fines about Section 135. For those of you that listened to my bylaw enforcement presentation a while ago, we went over that in a lot of detail, so you can refer back to that, but I will go over those at least in a brief summary. So there's a number of situations where Section 133 can be used. So it can be used, as I pointed out earlier, to recover damage to the common property. It can be used for removing items from common properties. So it could be that someone has garbage and other things on their balcony. It could be used to restore unauthorized alterations. And it can even be used to charge back legal fees to compel the enforcement of a bylaw. And there are differing views as to whether they can be applied in relation to legal fees for a CRT claim for bylaw enforcement. The key, however, to Section 133 is that you must identify a bylaw that has been breached, and the amount that's being charged back must relate to a step that's taken to remedy the breach. It can't just be in general relation to the breach. You have to have done something to remedy or cure the breach of the bylaw. So once you've laid the foundation for your chargeback, either Section 133 or a bylaw, you've notified the owner, then the question becomes, how are you going to collect this money? So the Strata Corporation has two options, one of which is to bring a claim at the Civil Resolution Tribunal. And later in the presentation, we're going to go through the steps related to that. Or they can wait to collect it under the Form F when an owner sells. So when an owner sells their strata lot, in order to transfer title, the Land Titles Office requires a Form F from the strata that says either all the monies owing have been paid or suitable arrangements have been made. It's at this point that the strata pulls out its ledger and says, well, here's what the owner owes. Owner, you have to pay this, or your lawyer has to undertake to pay this upon use of the Form F. And what route you go depends on a number of factors, often the amount that's outstanding. But the one thing that the strata has to be aware of is the limitation period. So under the Limitation Act, a strata corporation has 2 years to bring legal proceedings, which would be a CRT claim, in order to recover the amount outstanding. Now, Section 8 of the Limitation Act talks about when your claim has been discovered. And so there's 4 factors to look at. The injury, loss, or damage occurred. So something happened that's caused the strata corporation to have to spend money. That was as a result of someone's act or omission. You know who the person was who caused it, and essentially that suing would be the appropriate action to recover the amount outstanding. Limitation. Quite often, stratas will wait until they receive an invoice from the restoration company. That could be 6 months after the fact. That's not when it starts. You don't want to miss your limitation period. Moving on then to fines. So the very important thing with fines is to get your ducks in a row. And so I thought an illustration would be helpful, and I found these cute little guys looking very spring-like, and they illustrate the principle that your ducks have to be in a row. Not necessarily perfectly, but in a row. The reason for that is that the court has been very clear that strict compliance is required with the fine regime under the Strata Property Act. If you don't comply strictly with all of those steps, then the fines will be struck. And the CRT is ruthless in its application of that principle. So again, laying your foundation. If you're going to collect fines, you need to make sure that you've done all the steps that are necessary. If you haven't, then you may need to go back and redo them, or you may need to simply not pursue the fines. So Section 135 is the key to applying fines. So you have to have received a complaint. You have to have given the owner or the tenant who's breached the bylaws, the particular of the complaint in writing, a reasonable opportunity to respond. If it's a tenant who's breached the bylaw, you need to write to the tenant, copy to the owner, and that's also reflected in Section 130 of the Act. And this is a very common mistake that's made within the strata industry. And then if you've made a decision to fine, then you have to have notified the owner or tenant of that decision. And you'll see also that it talks about, in the last bullet point, charge a cost back. So that ties back to Section 133. If you've ticked off all those boxes, then you should be successful in recovering your fines. If you haven't, you're going to have some difficulty with that. The other key in applying Section 135 is that a fine cannot be put on the strata ledger until Section 135 is complied with. So again, I still see from time to time strata corporations that are just putting fines on ledgers. You can't do that without having complied with 135. If you do, again, you're not likely to recover those fines. However, a failure to comply with that section can be fixed either by reversing the fines and starting over again, or there's at least one CRT decision that says you at least hold your hearing under Section 135 before you go any further. My preference is the first. I think it's clearer and easier to argue compliance. So how do we collect fines? Similar to chargebacks, you can either bring a claim at the Civil Resolution Tribunal, or you can wait until the owner sells and collect it under the Form F. However, there's one key difference between chargebacks and fines, and that is that the limitation period does not apply to fines. That is because they're not an injury, loss, or damage, they're a penalty. So you can collect the fines at any point in time under the Form F. You don't need to bring a CRT claim. Some stratas in the past have tried to be creative with respect to how they collect their fines. An example of that is the Podwinski decision. In that case, the strata corporation had a bylaw that said strata fee payments are applied first to fines and secondly to chargebacks and then thirdly to strata fees. And the court said you can't do that. If someone's paying a strata fee payment, it goes to strata fees. The other thing that I also wanted to mention with respect to the limitation period, although you don't have that 2-year time frame, you may not always want to wait that long, particularly if the owner starts to dispute the fines. The longer you wait, the more likely it is that witnesses to the events will no longer be around. So you need to keep that in mind. The other is what I originally said back at the beginning of the presentation. Fines sometimes aren't effective unless they're actually had to be paid out of someone's pocket. So I'm going to talk now for a little bit about the Civil Resolution Tribunal, or CRT, because it is the venue now where the Strata Corporation will go in order to collect money that's owed to it. You'll see the first bullet point talks about the CRT's jurisdiction from Section 121 of the Civil Resolution Tribunal Act. It has jurisdiction over claims related to money owing, including money owing as a fine. So that's what gives the CRT the jurisdiction to rule on chargebacks and on fines and any other sums that are owed to the Strata Corporation. Section 123 of the Civil Resolution Tribunal Act allows the CRT to make an order requiring a party to pay money. So that's going to be the remedy you'd be asking for, is a judgment for the chargeback amount or a judgment for the fines. You cannot go any longer to court, either Supreme or Small Claims Court, to recover these amounts of money. Section 16.1 of the Civil Resolution Tribunal Act says that the court must refuse jurisdiction if the CRT has jurisdiction over the claim, unless it's in the interest of justice for the court to hear it. There is a test to be applied with respect to the interest of justice, but certainly it would not apply to a simple issue with respect to chargebacks or fines. So the CRT is your venue to pursue these amounts of money. So unlike commencing other types of litigation, no vote of the owners is required to commence a CRT claim. If the Strata is going to go to Supreme Court to sue over something, it requires a 3/4 vote. Same with respect to small claims, unless it has a bylaw that authorizes those small claims actions. One thing the Strata does have to do is consider funding. There's always the sticky problem of Section 169(1)(b) of the Strata Property Act that says an owner who is being sued does not have to contribute to the legal fees. So this, in a textbook world, would require the Strata Corporation to raise a special levy every time it went to pursue an owner to recover monies, and that special levy would be one to which the owner being sued does not contribute. However, the practical approach is that the Strata Corporation will usually spend the money just out of the operating fund and then give the owner a pro rata refund at the end of the day. The Civil Resolution Tribunal, for those of you who haven't had experience with it, is quite a unique venue. It is online, and arguments and evidence are uploaded. The general rule with it is that parties, and in this, since we're talking about Strata Collection, in this case, a Strata Council member will represent the Strata Corporation. What that essentially means is that that person is the liaison between the Strata and the CRT case manager. That rule, though, does not preclude the Strata from getting help with its case. The CRT rules and literature talk about having a helper. That's a person in the background who helps put things together, and lawyers quite often fulfill that role, both in terms of drafting the initial claim, helping assemble evidence, and assisting in putting together the written argument that will be reviewed by the CRT adjudicator. However, where a case is complex, the CRT will allow a lawyer to represent the strata, which means that that lawyer would be the liaison directly, not the strata council member. If you are going to go to the CRT to collect money, there are first things first, and that is under Section 112 of the Strata Property Act. The Strata Corporation has to send a demand letter to the owner. So that demand letter must give them at least 2 weeks to make a payment, and then indicate that the claim will go to the CRT if the amount is not paid. Lots of strata corporations are in the habit of sending out general AR notice, that with notations about if you don't pay, certain things will happen. That likely isn't going to be sufficient to meet the requirements of Section 112. It would have to be reviewed carefully. The better, more safe practice, in my opinion, would be for the strata simply to send a new formal letter making that demand. So when it comes to sending out that Section 112 letter, the devil is in the detail. And so there's a number of important specific things that need to be looked at. One of those is complying with Section 61 of the Strata Property Act in regard to the method of notice. And on the next slide, I'll just review those various methods. In the Manji decision, that case dealt with the filing of a lien, but it addressed a number of these issues, one of which was whether notice was properly given. And in that case, the Strata Corporation had sent the letters, there were several strata lots in arrears, they'd sent all the letters to one unit and sent them via registered mail, and the court said that that wasn't compliant with Section 61. The other is get the number of days right. So this is what I like to refer to as lawyer math. Where the Section 112 says at least 14 days, that's actually 20 days, because you don't count the day you send the notice, you don't count the day it's received, and then Section 61 sub 2 has provisions with respect to when notice is deemed to be given. It's usually 4 days after it's mailed or emailed, so you have to add all that up. This again is an issue that came up in the 228 Chateau Boulevard cases. And then the last thing is mention everything that you're going to be sought. So in the Angaro Properties case, there's a number of different chargebacks and items that the strata was seeking judgment for from the owner of the strata lot. In that case, the CRT denied at least one of them because it wasn't referenced in the demand letter. So be specific with respect to what you are requesting. And sorry, talk about Section 61 just in a minute. The 228 Chateau Boulevard trilogy, there's 3 cases, and it's really an example of what not to do when you're trying to recover a chargeback. So you'll recall that I had said earlier that the case was about recovery of damage caused by the rupture of a hot water tank. In this case, it was about $24,000. The strata was relying on Section 133, and it proceeded to charge the amount back to the owner of the strata lot, but it did it without complying with Section 135 and giving them a hearing. It put the amount on the ledger, reluctantly gave a hearing after the fact, and then proceeded on. The first decision in 2018, the CRT dismissed the case because they said the amount should have come off the ledger, then had the hearing, and then gone back on. CRT left it open for the strata to try again. So they tried again, trying to get all their ducks in a row, to use that analogy. The second claim was dismissed because the strata failed to comply with Section 112. I didn't give 20 days notice. I gave, I believe, only 7 days notice. So again, the case was dismissed, opportunity to bring it again. Third kick at the can, the strata once again failed, because by this time it had missed the limitation period, which gets quite tricky because the CRT legislation talks about the limitation period being suspended once the claim has been brought. So there's a number of stops and starts, but at the end of the day, when they added it all up, they had gone past the 2 year or 24-month period and weren't able to recover the monies. So I thought those cases were worth reviewing because they're an example of the pitfalls that really can arise and the issues that the CRT is going to be looking at and that you as a strata need to make sure you've addressed before you head down the path of bringing your CRT claim. Coming back to Section 61 and the notice issue. So Section 61 lists a number of ways in which notice can be given to an owner. The most common of those are slipping it under the door of the person's strata lot, mailing it, or you'll see the very bottom, you can email it to someone so long as they've given you that email for the purpose of providing notice. A couple things to catch there is, as I said, the email for the purpose of notice, not just simply if you have an email address are you allowed to use it. The other is if the owner doesn't live in the strata lot and they've given you an address outside the strata lot to send mail to, that is the only method you can send it by. You can't email them. So beware the Form K if you have an owner who's renting a strata lot and they've put their non-resident address on the Form K. That can be notice requiring you to send it to that other address as opposed to the unit itself. One of the questions that I'm often asked and that stratas have to consider is, can it recover legal fees in relation to the CRT proceeding? And the short answer to that question is no. Rule 9.5 of the CRT rule says the costs are only awarded where there are exceptional circumstances. And I could probably count on one hand the number of cases where the CRT has held there are exceptional circumstances that would allow for the recovery of legal fees. Typically, exceptional circumstances, as you'll see in the second bullet point in the Parfit case, result from conduct that has occurred during the course of the proceeding and conduct that's deserving of rebuke. So in that particular case, there was some expletive-filled emails that were sent by one party to the other, to which the CRT felt there should be some award of costs as a penalty. The exception to that law, being much about a rule and a number of exceptions, is that a bylaw allowing for recovery of legal fees can be considered an exceptional circumstance. So when I prepare my bylaw packages for stratas, I have a bylaw that allows it to charge back to the owner all the legal fees that it incurred in going to the CRT, either to enforce a bylaw or to recover monies that are owed to it. One more thought just before I change slides. Given the legal fee issue, if you don't have a bylaw that's going to allow for recovery of legal fees, then the Strata Corporation is going to have to make sometimes a cost-benefit analysis. Is it worth incurring the fees to pursue the amount outstanding? Sometimes it is. Sometimes it isn't. The other may be on a point of principle. You may have to incur legal fees to collect fines in order to make your point. And that's a decision that each strata council is going to have to make in weighing up its duty to act reasonably, prudently, and in the best interests of the Strata Corporation. So if you've gone through the CRT process, you've ticked all the boxes, you've gotten your judgment, what do we do with it and how do we get it paid? Because simply because you have an order that someone pay you money doesn't mean that they're necessarily going to do it. So there are a number of ways that you can collect on a CRT judgment. The first step, though, is you have to take that judgment and you have to file it in court. So it can be filed in the provincial court, small claims, if the amount of the money is under $35,000. If it is over $35,000, which is the limit of the small claims court, then it must be filed in Supreme Court. Once it is filed, it becomes an order of the court and then can be enforced as an order of the court, depending both on the rules of that court and the Court Order Enforcement Act. There is no vote of the owners required to file the judgment in court. It's not commencing a separate legal proceeding, it's simply taking a step in furtherance of the CRT claim. Once it's filed, then you have several options to compel payment by the owner. One of those is to garnish the owner's bank account, which requires completing and obtaining a garnishing order. That is a good option for stratas because they know the owner's bank account number. They're paying their strata fees every month. The one thing to keep in mind, though, is that the bank has a right of set-off. So I may have $10,000 in my bank account, but if I owe the bank 20, then there's nothing for anyone to garnish. The strata can also seek a payment order if the judgment is registered in small claims court. That's a proceeding where the strata corporation takes the debtor owner before the judge. The judge has a chat with everyone. The owner has to explain why they can't pay, and then the judge can make an order that they pay a certain amount every month. Two things to keep in mind there, one of which is sometimes those amounts can be quite small. Secondly, and more importantly, once a payment order is made, the strata corporation is not entitled to take any other enforcement steps. The third option is to send the sheriff to seize assets. There are certain exemptions at law as to what things an owner can't have seized. But certainly if you had an owner that owed money and you know they have that RV sitting in the RV parking area of the strata, you could get a writ of seizure and sale and send the sheriff or the bailiff to seize it. The most common method, though, of enforcing a judgment is to register it on title to the strata lot. And that allows the strata corporation to do a couple of things. It can then proceed, once the judgment is registered, to seek a sale of the strata lot to satisfy the judgment. That is a separate legal proceeding, and that would require approval by way of a 3/4 vote under Section 171, and again, the raising of funds to do that. It is not a proceeding to enforce a lien, which we're going to talk about at the end of the presentation, is how to collect your strata fees. So you don't have the same benefit. A lien ranks in priority over other charges. Here it doesn't. However, one of the reasons that you would want to proceed to get the strata lot sold is it's a way of compelling the money to be paid. The other option is to wait until the owner sells or refinances. If they do it at that point and there's a judgment on title, that judgment has to be cleared off or paid out. Two things to keep in mind there. A judgment that's registered on title has to be renewed every 2 years, otherwise it lapses. And then you have 10 years within which you have to sue to sell the strata lot to collect on the judgment. Otherwise, the judgment itself lapses. One of the benefits of even just registering on title and waiting is it does make the strata a secured creditor, particularly if a bank forecloses against the strata lot. You are going to be on title. You'll get paid out in priority, listed on title, but at least the bank will have notice that those monies are owed. Strata fee collection is quite a different matter. There are 3 ways to collect strata fees. You can go to the CRT for strata fees. Again, it has jurisdiction over money owed to the strata corporation. You can file a lien under Section 116 of the Strata Property Act, and then Sections 117 and 118 pertain to enforcing that lien. Or again, you can collect outstanding strata fees and special levies under the Form F. The lien, in my opinion, is the preferable option, and I'll explain why. The lien has quite a few benefits. It ranks in priority to other charges. So as soon as you register the lien, the strata corporation jumps ahead of anything else that is on title and gets paid out first. The exception to that is charges in favor of the Crown. So if there was a judgment on title for a tax debt, the strata would be behind that, but ahead of the mortgage. It also makes the Strata Corporation a secured creditor in the event of a bankruptcy. In theory, if the Strata does not have a lien, it's unsecured and would participate pro rata with other unsecured creditors. It's also a very straightforward process. Unlike what we looked at with the CRT, where you have to go, you have to get a judgment, you have to then take it to a court and register it, and then pursue one of these various other steps, the enforcement of a lien is a straightforward, fluid process, one venue done through the Supreme Court. It also allows for the recovery of legal fees. The lien process involves several steps, and it's rather, when we do this in our office, it's rather methodical. They go through the various steps, diarize to move to the next one at certain standpoints. Just as with proceeding with a CRT claim, you have to start with the demand letter. And so you have to make sure that the demand letter meets all the criteria of Section 112. And also that it separates out the amounts that would be lienable from any other amounts. So although you can demand them all in the same demand letter, your letter needs to make very clear that this amount is subject to a lien, this other amount is subject to a CRT claim. Once the Strata has sent that demand letter, and has waited we use 21 days just to be safe, that we don't miscount the 20. It can then proceed to file a lien against title. It's at this point that we typically notify the lenders. The reason I wait until then is because at that point it's public knowledge. If you notify a lender before then, you run the risk of breaching the Personal Information Protection Act because you're telling them information about an individual owner. If the lien is not paid, then at some point the Strata Corporation has to commence a petition for judicial sale. One of the things that informs when you do that is, again, that 2-year limitation period. You have to make sure that you don't miss that when it comes to strata fees. Once the petition is filed and served on everybody, then you set a court date. The court will set a deadline for the owner to pay. In this sense, it works very much like a bank foreclosure. The owner will have usually 30, sometimes longer, 60 or 90 days to pay the arrears. If they fail to do that, the Strata Corporation is then given the right to sell the strata lot. And so it will then list it for sale, take offers, and then we'll go to court. The court will approve an offer. The unit will be sold, the owner will have to move, and the strata will get paid. So a few things to remember with respect to the lien process, which I hinted at already, was, of course, the limitation period. So it does apply to strata fees and special levies. It starts to run the day after the payment is due. So if you miss your July 1st strata fees, July 2nd, that 2-year clock starts to run. Now, if you have large arrears and an owner is making payments towards it, for example, say there's a $10,000 special levy, they couldn't pay it, but they're making $100 payments every month. The limitation period starts or restarts with each of those payments as they're making an acknowledgement. However, if you're allowing an owner a long time to make payments, you should have an agreement in place that addresses the limitation period. One very important thing to remember is that the filing of the lien does not stop the limitation period from running. I run into this issue fairly often, where somebody thought simply by filing the lien they were good. The Limitation Act refers to commencing a court proceeding. Filing a lien is not a court proceeding. The other thing to keep in mind is you cannot collect expired amounts. So the Cornleo CRT decision, the Strata had collected expired strata fees that were older than 2 years on sale of the unit. They were ordered to pay it back to the owner because once the limitation period expires, then those amounts are no longer collectible at law. I'd mentioned earlier the Manji decision, and it's really important when it comes to liens because it talked not only about notice issues, it also talked about the 14-day notice provision. It went on to address what actually can be included in the Form G lien. That's the lien that's registered in the land title office. Quite often when liens are registered, somebody simply looks at the account statement and goes, oh, they owe $1,200. We're putting that in the lien. That amount may not represent solely strata fees. It may include fines. It may include the cost of the demand letter. The Manji decision said none of those amounts can be included on the face amount of the lien. Only the things that are collectible under Section 116, which are strata fees, special levies, can be on there. Fines, legal fees, although they are collectible, can't show up on the face amount of the lien. If any of those amounts are included in the lien, they are the lien would be invalid and unenforceable. Legal fees are, again, one of the big benefits of the lien process. So Section 118 says that legal fees incurred by the Strata Corporation to register and enforce the lien are included in the lien amount. Now, again, to square that with the Manji decision, those don't appear on the Form G that is registered in the land titles office, but when the owner comes to pay out the lien, you add those to it. Now, it is the actual amount of the legal fees spent by the Strata Corporation so long as they are reasonable. And ultimately, the determination of reasonable would be made by the registrar of the court. There was also a fairly recent case that said demand letter costs can't be charged back to the owner unless there is a bylaw. So quite often, strata corporations will have either the strata manager or a strata lawyer send a demand letter, and those costs will be charged back to the owner. This case, the 625536 PC case, said that that can't be done. They're not part of the lien cost per se unless there is a bylaw that allows you to do that. So long as your legal fees are reasonable, the Strata Corporation should not be out of pocket for hiring a lawyer to pursue strata arrears through the lien process. So in summary, just before we open up to Q&A, a few things I'd like you to take away from this. One of which is review your strata bylaws and make sure they have provisions for chargebacks, including charging back deductibles, and legal fee recovery. If you don't have those bylaws, you should update your bylaws to make sure you've got them. Go back and review your accounts receivable for amounts that are either nearing or past the limitation period. Those that are nearing, you're going to have to make a decision as to how you're going to proceed to collect those. Those that are past, you're going to have to just simply write those off. And then I always encourage strata corporations to implement a standardized collection process and then budget accordingly so that you can make sure that you are pursuing your arrears in a timely fashion. So thank you, ladies and gentlemen, for sticking with me through that. I'm now going to open it up to some questions.
First of all, Sean, because we end the recording in just a few seconds, I want to, for the purposes of our recording, thank you so much for doing this webinar. It's been incredibly informative